So Leah sort of teed up Adam's talk perfectly, but sort of maybe threw, not intentionally, threw me under the bus because they presented this fantastic way to collaborate and work with organizations. And it runs counter to my way of trying to get organizations to do things, which is to functionally shitpost by giving conference talks. So knowing that that's not necessarily the most effective strategy, but I can't change my slides at this point, here we are. So I'm going to talk today about legal restrictions on vulnerability disclosure in the context of bug bounties. And I want to start with a little bit of history. So I want to take everybody to take themselves back to 1989. So the Berlin Wall falls. People have the internet in their homes in ways that make really weird noises, which I will not attempt to imitate, although it would be really funny if I had prepared well enough to do that. I'm referring to modems. And a guy named Clifford Stahl wrote a book called The Cuckoo's Egg. Have people, all right, there's like a couple, thank you. And in that book, which if you haven't heard of it or read it, I really recommend because it's sort of a spy thriller about charges on a mainframe system at UC Berkeley. In the acknowledgements, he has some text that I want to share with you, and this is again from 1989. He says, how do you spread the word when a computer has a security hole? Some say nothing, fearing that telling people how to mix explosives will encourage them to make bombs. In this book, I've explicitly described some of these security problems, realizing that the people in black hats are already aware of them. Now, I think of this quote as sort of, it's an early usage of the phrase black hat, which is sort of interesting, but also as a sort of statement about the public good in disclosing security flaws and the sort of maybe an indictment of a kind of security through obscurity mentality. And I think in some level I kind of had thought for a long time, and maybe this is just my own naivete, that this was a debate we kind of settled a while ago, right? That, we'd sort of Clifford Stahl won, right? Like this idea that the goal of covering up vulnerabilities or not disclosing them was the way to better security was like not where we were going. But I have some bad news, which maybe a lot of folks in the audience already know, which is that a lot of vulnerability reporting now takes place under formal non-disclosure agreements. And all it took to get there was a couple of centralized platforms and a lot of lawyers. So in this talk, I'm going to talk a little bit about the history of why I think that's weird by talking about sort of debates over the concept of full disclosure and the history of vulnerability disclosure. I'm then going to talk about responsible disclosure in our year 2025 with some examples that I have not removed the names from. I'm then going to talk a little bit about why I think the status quo here is not good, and then what I think folks can do about it other than shitpost conference talks. So let's talk a little bit about history. And if you live through this, you can tell me off about how I got everything wrong later. So first, before I do that, I want to talk a little bit about terminology. Right? So I'm going to talk about bug bounty programs and vulnerabilities disclosure programs. I'm going to talk about them a little bit separately. When I use those terms, and I'm not claiming that I have some perfect universal definition, but what I mean is that vulnerability disclosure programs are organized, structured ways for researchers to report vulnerabilities, primarily to companies. And bug bounties are programs where researchers can be paid for reporting vulnerabilities. It's worth noting that most bug bounty platforms today divide these into two categories. Public is sort of open to anyone who can on the platform can submit to, and private or invite only, where only select researchers can submit. So I'm going to primarily be talking about public bug bounty programs, not private ones. Platforms run both of these types of programs, and I'll talk more about it, but I'm talking about organizations like HackerOne or BugCrowd. But they often distinguish them or sort of put them in separate categories. It's interesting in part because other organizations that sort of run their own in-house programs, think Google or Microsoft, don't really necessarily distinguish this in the same way. You don't see the sort of, I think in my experience, the same sort of very clear separation. But when I talk about bug bounties, I mean the parts that pay out. When I talk about vulnerability disclosure programs, I mean sort of the programs more generally, but not ones where we're specifically talking about getting paid. Okay. Now that we're clear on terminology, or as clear on terminology as we're probably going to get, let's talk a little bit about the history. So what I'm talking about here is the fights over disclosure in the 1990s and early 2000s. So between 1993, so I'm picking that year because that's the creation of the bug track mailing list, and the early 2000s, there was a debate that was raging over how vulnerabilities should be handled. You see these basically, I'm going to divide them roughly into two camps, but of course, like all binaries, there's plenty of stuff that doesn't fit well into that. People sort of perceiving that reporting to vendors or to CERT, was throwing information into a black box, unlikely to result in fixes, and keeping vulnerable users in the dark. Whereas others sort of viewed releasing more detailed information about vulnerabilities publicly as in its own way to bring harm to users, or sometimes even as a form of extortion. Now, this kind of false binary that I'm talking about here is the debate over non-disclosure versus full disclosure, and that's probably the term that most folks are familiar with this context on. But basically, the idea here of full disclosure is releasing information on vulnerabilities publicly without giving a vendor a heads up first. So maybe we could call it non-coordinated vulnerability disclosure. But this debate was not only just like individuals, right? Some organizations, notably open source ones, were pretty comfortable with full disclosure, especially when the sort of idea of creating a patch was a collaborative one that was going to take place in public anyway. Where others decried it, right? Especially large companies that were sort of the targets of much of the ire. These debates are inextricably linked at this time and to conversations about credit and professional brand building, because part of what's happening in the context of full disclosure is taking credit for something you found. And for more on this history, I'm drawing from a piece by Matt Gorzin and Biela Coleman called Wearing Many Hats, The Rise of the Professional Security Hacker. So you should totally check out that piece if you want to read more, or frankly, I think the 50th anniversary of USENIX celebration, if you find anybody who looks sufficiently old and offer to buy them a beer, you also may be able to hear more about it there. So what I want to emphasize here is that full disclosure was a political act, right? This is from another fantastic piece that talks about this. This is by Ryan Ellis and Yuan Stevens. And what they say is full disclosure was a protest, a middle finger to software companies that were often seen to be slow to respond to reports of flaws. Rather than reporting bugs and waiting and hoping that a security company might eventually fix the problem, full disclosure attempted to force software companies to react fast. And it's an interesting context because I think sometimes, we sort of see where we ended up, and it can, full disclosure, of course, is in some ways quite dramatic. I think that's part of how it works as a political act. But it was also sort of a statement about who held the power in that situation. Was it the company that could decide when it was going to pitch the fix, or was it a researcher that was now going to sort of potentially get press attention, cause problems on purpose? No, but potentially point out to users that there were real flaws in this software. So again, my short and very abbreviated history. In early 2000s to the mid 2010s, the ecosystem is changing, right? You get this sort of idea, which I kind of think of as a middle ground of timelines, right? We're gonna make it public in 45 days. We're gonna make it public in 90 days, which sort of give time to patch while respecting the concerns that full disclosure practices come from, of the idea that sitting on these the reports of vulnerabilities forever makes it really hard for people to know what's going on, and that companies don't often have incentives to disclose. You see the establishment of formal vulnerability disclosure programs at companies like Microsoft, and you get the term coordinated vulnerability disclosure, which I made fun of earlier. And it becomes popular in the early 2010s in part because responsible disclosure, which was a term people were using prior to that, is pretty loaded, right? Like, this is the responsible way to do this. And this comes along with this idea of coordinating on public release. So it's a conversation. And of course, you get the rise of formal bug bounties, Google, Facebook, et cetera. Although, of course, the first bug bounty program dates back to, anyone want to guess what year? 1994. Thank you. So 1994, 1995, I'm going to go with the earlier year because it's easier, but that would be Netscape Navigator, truly ahead of their time. So what's interesting here is that we also have some evidence that the full disclosure people were kind of maybe right about some stuff, right? Which is to say timelines work. there's a reason to sort of tie organizations to the mast about going public. And if you don't believe me, which you shouldn't, you should take it from Project Zero instead. So this is a quote from the Project Zero FAQ. Project Zero, of course, being Google's folks who are finding vulnerabilities. They've sort of said they've gone through a whole bunch of different vulnerability disclosure methods, and we've decided on a 90-day disclosure policy. And they list the examples of when they made exceptions to that. And they specifically note that, turns out people patch stuff faster when you give them a deadline, which, none of us who've ever, procrastinated on a conference talk could ever relate to in any way. The other thing that happens in this context is the rise of bug bounty platforms, right? So here I mentioned these earlier, but you have BugCrowd, HackerOne, Syntac, Integrity, and founding in the early 2010s, but often sort of much more popular kind of later on. They make it easier for companies that don't necessarily have a dedicated sort of goal of making these programs to run vulnerability disclosure programs and sort of create what Stevens and Ellis talk about as a marketplace for these vulnerabilities that existed separate from kind of the black market, and of course was in conversation with the no free vulns, no free bugs kind of discourse around sort of finding vulnerabilities. Okay, so again, short potted history, yell at me later about all the stuff I got wrong, but let's talk about what it looks like in 2025. And yeah, I have not redacted the names of the companies that I'm talking about because, that's not my problem. Okay, so this is a responsible disclosure policy. By participating in this program, you agree not to share publicly or privately any details or descriptions of your findings with any third party. You also agree not to attempt to threaten or extort Amazon. It's nice. Amazon commits to timely remediations of your findings, great, and prompt response to relevant questions. So it's interesting to call this a responsible disclosure policy, which I guess it is, in the sense of you can't disclose, and you better hope they're responsible. But okay, Kendra, I can imagine the person in the audience who is was maybe not thrilled to hear that they come to the shitpost conference talk and was like, but maybe this is what's best for the industry, right? Maybe this is, all of that Project Zero timeline, history stuff aside, actually, maybe this is the right outcome. So if that's you, maybe it is, I want to just point you to T-Mobile. So this is from these are all from either HackerOne or BugCrowd, and this is from their disclosure, their guidelines on, I think it's BugCrowd. So if you're going to disclose a vulnerability to T-Mobile, you will not discuss that vulnerability, even resolved, outside of the program without prior written consent from T-Mobile. Any absent T-Mobile's prior written consent, any disclosure outside the program would violate this agreement. But if T-Mobile is going to disclose a vulnerability to a third party, they give them 90 days. Now, I find it a little hard to square that with the idea that there's a correct, that this isn't a question of sort of perhaps power or who has, the right to do what. And again, I want to maybe come back to my responsible disclosure in 2025, which is that timelines are for other people's security teams. But okay. Imagine interlocutor who's arguing with me says, those are bug bounty programs, and that's different because people are getting paid. So it would be one thing if it's, for pay, but I guess it's different if it's a vulnerability disclosure program where people aren't getting paid. This is Citigroup. This is their responsible vulnerability disclosure program. Please be aware that Citi will not correspond with you directly, disclose remediation steps or timeframes. You should not publicly publicize or disclose your submission or the results to any third party. Please don't discuss the vulnerabilities, even resolved ones, outside of the program without express consent. So it's not just bug bounties, right? This is a vulnerability disclosure program where no one's getting paid. But okay, these are on platforms. You should just report the vulnerability without using these programs, and then you're not going to get bound by the non-disclosure agreement. I have a feeling people can probably guess what's coming next. But great, I'll do that. Look, there's this fantastic button on Citi's website where I can submit a vulnerability. Oh, when I click on it, I'm now going to a third-party website. That's interesting. Oh, I'm on BugCrowd, and oh, look, that's roughly the same language about not corresponding with you directly, and you may never disclose. So this isn't a circumstance where you can just sidestep, in at least some cases, these non-disclosure requirements by submitting some other way, when the way to submit is through these programs with this requirements. And if anyone's seen Archer, what I would say here is, do you want full disclosure? Because that's how you get full disclosure. These are public programs, both with and without monetary awards. It's not all of them, but it's a lot of the ones run through platforms. And if you want to report a vulnerability, you will often be contractually required to not talk about it without company permission. And I think I've covered in the history section why actually there's a plenty of back and forth about why companies often have the incentive to not give folks permission to disclose vulnerabilities. So now we get to the point where why is a lawyer giving this talk? Especially one who was not active in the vulnerability disclosure debates of the 1990s. Let's go with that. So I want to talk a little bit about why I think this sucks, which I'll put into the category of what's different now and why is this bad. So I think when you think about the sort of debates that were occurring earlier, there's sort of expectations of non-disclosure. But now we're looking at actually specific contractual agreements. And although I think there are sometimes quite good arguments that people should not be bound by those agreements, that researchers should not be bound by those agreements, I don't, like, that is a very different position to be in than a sort of informal expectation that something is not disclosed until it's fixed. The other thing is that these clauses effectively prohibit discussion of labor conditions. And for this, I'm going to reference again the fantastic work Bounty Everything by Ryan Ellis and Yuan Stevens, where they point out that saying you can't disclose a vulnerability that you report but is closed as a duplicate or is said as out of scope actually speaks to the conditions to which people are laboring on the platform, like a Bugcrowd or HackerOne. That is basically their workplace. And these are decisions about sort of what's getting paid out. And if you can't talk about that contractually, you're in a position where folks can't compare notes about, hey, wait, are they literally, is this company literally closing lots of stuff out of scope for, even when it's not? Or is this company really great and really fantastic to work with? You do get statistics, but I'll move on from that. This is also a problem if you have obligations to engage in disclosure. For example, like an academic conference that expects you to disclose vulnerabilities to a company before you're allowed to, present it at event. My last thing, which I will not stress, because I think in some ways it's the one where I am least convincing on, is the idea that I do think we have some evidence about kind of why non-disclosure for the long term is not great. Two other points. There's this interesting chaining effect that goes on these platforms with safe harbors. So in 2018 at USENIX Enigma, Amit El-Azhari gave this talk called Hacking the Law, Are Bug Bounties a True Safe Harbor, where she proposed basically making much more explicit safe harbors present on bug bounty platforms for researchers. And that she successfully convinced folks that this is a thing that should happen. This is Amazon's. But those safe harbors are contingent upon following the rules of the program. So now as a lawyer, I have to think about whether if someone does disclose sort of in a way that is not consistent with the program terms, have we now sort of set them up in a situation where I now need to think about their liability under all of these other things that would have been considered as under a safe harbor previously because of their violation of those terms. And I got to tell you, as someone who's done versions of that analysis, it's not very fun and I don't recommend it. The other thing to think about here is the relationship to platform terms of service. So failure to follow the rules here is not just consequences for one program, that one company, but potentially all programs that are run on the same platform. So this is the chart from HackerOne about their sort of what can get you kicked off. So that is to say that not just from a financial perspective for bug bounties, but to the extent that many companies are running their programs through these platforms, disclosing in a way that a company does not like potentially jeopardizes your ability to report other vulnerabilities through the expected methods. But OK, imagined interlocutor says, platforms and programs wouldn't use these terms if someone was actually disclosing in good faith. Why can't you just trust them? Well, I mean, did you pay attention to the history part? But besides, also, there's this concept called chilling effects, right? Where even if folks think it is appropriate to disclose a vulnerability given the sort of equities of the situation, they may, quite reasonably feel that they're contractually unable to or can't pay a lawyer to do it. maybe you're thinking, well, my company wouldn't sue researchers for public disclosure, which is great. So your company can get rid of the terms that require non-disclosure if it wouldn't use them. Basically, my point here is that there's sort of this way in which I think this discretion functions one directionally, right? I think of the quote, for my friends, anything, for my enemies, the law, but instead it's for software vendors, anything, for security researchers, the law, right? If indeed these are discretionary, then we should be giving the discretion not just to the organization with more power in these circumstances. I'm gonna quickly get through what can be done before I go to Q&A. So, some folks in this room are, work at places with these kinds of programs. And I do actually, all jokes aside, I think that I understand that there are equities internally that I can't see as an outsider. But I think if you do work at a company, I would encourage you to go check the terms on your VDP or a public bug bounty. And if you wouldn't like them for a third-party vendor, or if you are in a position where you would potentially submit a vulnerability you found and you wouldn't feel comfortable submitting to those terms, I think that's a good argument that your company shouldn't be imposing them on external researchers, and you may have to explain to other stakeholders why. You can decide for yourself whether when this talk gets recorded, whether this talk is an effective vehicle to do that. It may not be. For bug bounty platforms, I don't think it's appropriate to grant legitimacy to vulnerability disclosure programs with non-disclosure requirements. I think it violates the fundamental sort of promise of what this stuff is supposed to do, and I think it disables the ability of folks to learn from vulnerabilities that other people find. And at the very least, many of these platforms have sort of what I'm going to call gold star. They sort of ways in which they certify programs as belonging to a higher tier or appropriate. I do not think these sort of indefinite non-disclosure, and by that I mean disclosure at company discretion, which is the same thing, should be Gold Star eligible. And I also think there's some conversations to be had about defaults and messaging and expectation setting. And I think some platforms do this differently than others in terms of how that works. For conferences. Hi, USENIX, which actually I think the vulnerability disclosure policy here is quite good, but make clear that if reporting a vulnerability requires indefinite non-disclosure at company discretion, researchers can seek exemptions to general policies that require disclosure, or can maybe find ways to do it that aren't necessarily the ones that we would usually use. And that may mean working with CERT. There's other stuff you can think about here that might be different than sort of these traditional channels. Finally, for researchers, because that's probably most relevant in a lot of circumstances, you do need to look at the VDP and bug bounty program policies. I'm sorry. If a VDP requires non-disclosure, I would consider trying to find an insider channel for reporting. So, lots of folks do this by making direct contact with folks at an organization. If you're asked to agree to an NDA, I think explicitly stating that you will not, and setting a timeline instead, honestly, I think that's probably all jokes about this is how you get full disclosure aside. I think that that's probably often going to be most consistent with what will be least likely to result in escalation. If all else fails, get a lawyer. Sorry. But what I want to close on is by coming back to this discussion about responsible disclosure, which is sort of this term that, again, fell out of favor because it's kind of values laden. And I want to say that my, remix of it for 2025 is to say that it's not responsible to require a vulnerability reporter to never disclose without permission via contractual agreement. So much of the conversation about responsible disclosure was assuming that the responsibility was lying on the person who was doing the disclosure to handle it in an appropriate way. This to me is not behavior that indicates like the kind of care for the ecosystem that I think we want to see from companies, where oftentimes reporting a vulnerability, especially in the context where you're not thinking about bug bounties, is kind of a pain, right? So that's my shitpost talk. I have some further reading suggestions for folks who are curious, and I want to thank the folks who helped me think this through and talk to me about it, and I'm looking forward to y'all's questions.